Limited. My lord, parties are absent in court.
Appearance. Hello.
Hello, my lord.
Appearance.
My lord, none yet.
Since they have been put on notice and they promise to participate via Zoom, I think I can go ahead and deliver my judgment. And I will just go straight to my decision. I have painstakingly studied the facts of this case as given in the various processes and evaluated the evidence of parties as it were. And I think the issue formulated by the defendant is enough to determine this case, one way or the other. That is, whether the claimant has proved that the determination of his employment was not in accordance with the terms of his employment to be entitled to the relief sought. However, before I delve into the issue, it is incumbent to consider the defendant's reply on point of law to the claimant's final written address filed on the 6th December 2022. The defendant's reply is predicated on issue 1 formulated by the claimant in the final written address, which is whether the termination of the claimant's employment can be said to be lawful and valid, same having been done in disregard of the defendant exit procedure for its employees contained in Exhibit CW-115. This is the issue the defendant wanted the court to discountenance because the claimant did not plead or lead evidence of the exit procedure of the defendant and therefore cannot use his final address to establish a matter he failed to lead evidence during trial, relying on EFA versus ITA and another. I want to observe that the claimant has devoted a substantial part of his final written address on the failure of the defendant to adhere to the exit procedure in Exhibit C in Article 11.2.6 of the defendant employee handbook, that is Exhibit CW-115. Not only did the claimant reproduce the provisions of section of Article 11.2.6 in the final address, but he said to elaborate on the 5 steps to be taken by the defendant before termination of the claimant employment. The question here is the issue of exit procedure born out of the facts of this case? I think not. I have taken a hard look at the processes and the record of proceedings and cannot find even an indication of the vaulted exit procedure in Article 11.2.6. not in the statement of facts, not in the reply to the statement of defense, not in the examination in chief of the two claimant witnesses, not in the cross-examination of the defendant witness. But under the circumstance, it is difficult to agree. Under the circumstance, sorry, it is not difficult to agree with the stance of the defendant that the claimant cannot use his final address to establish a matter he failed to lead evidence during trial. I am fortified in this regard by some notable principles on the subject as initiated in the following judicial authorities. First, it is tried law that counsel address cannot, however brilliant or logical, constitute evidence in a matter. And so any submission on facts not pleaded goes to no issue. See the case of Tachang and Lacret, Kasim and Masoku, Obiara and Obazwe, Ofondu and Mayegba, Allied Bank and Okumbuze, to mention but a few. Second, address of counsel is a summation of facts admitted, proved, and deemed considered in the trial and the relevant law applicable to the facts. It is the means by which counsel seeks to persuade the court to lean in favor of his client. The purpose of address by counsel to a party is to demonstrate to the court and counsel for the adversary his opinion of the facts and the law as shown by the evidence before the court. Facts not pleaded and proved cannot be part of counsel's summing up on facts and the law before the court and must be rejected. This is the case of Omisire and Oreb Bosola. Third, address of counsel must not only flow but be consistent with the evidence adduced in the case. See Fabei, Justice of the Supreme Court, in the case of Obideke and the state. Thus, and I quote, let me say that address by counsel should be tailored to be in line with the real evidence of record and not otherwise. This is so as the address are designed to assist the court. No amount of brilliance in fine speech can make up for the lack of evidence to prove and establish or else disprove or demolish points in issue. There is no need to make submission against the flow of evidence in a bid to procure and deserve attention. See neither construction of Okumbe Benin, end of quote. 4, on the authority of Niotola and Otu, granted that exhibit CW 115 was in evidence, it was no license for the land council to come the said exhibit and use materials that came his way as if they were facts pleaded and evidence adduced at the trial. It is only when parties join issues on the exit procedure that it will properly be part of the evidence in the case, and the court is entitled to consider it as such. 5, the introduction of the issue of exit procedure at the point of address without pleading is to say the least an ambush which the law frowns at. This is particularly so because pleadings are to be served on an opponent to enable him be on notice of the facts to contend with at the hearing and also to avoid springing surprises on the party. See the case of George and Dominion Flour Mills, George and UBA, Aduko and Kasamo, Agala and Okosi. In the light of the foregoing, I have no hesitation in accepting the invitation of the defendant to discountenance the submission of the claimant on the issue of exit procedure in this case. I take judicial cover in the dictum of J.I. Okoro, Justice of the Supreme Court, in the case of Eze Iyamu Osagwe and Knight and INEC, when he said, secondly, an issue merely raised by counsel in his final address as done by the appellant in the case cannot be part of the evidence before the court and ought to be discountenanced. The law is tried that the address of counsel, no matter how brilliant and erudite, cannot take the place of the evidence on record. See the case of Dabo and Salenka, Commissary and Oribe Shola. End of quote. Issue 1 formulated in the final written address is thereby hereby discountenanced in this judgment. The cause is now clear for the consideration of whether the claimant has proved that his termination of employment was in accordance with the terms of his employment to be entitled to the relief sought. In the determination of the validity of the termination of claimant employment, I have been most guided at all times by the dictates of the Supreme Court in the long line of cases such as Cato and CBN, Ibama and SPDC, Zidel and RSCSC. The underlying principles in all these cases and many more is to the effect that an employee seeking the declaration that the termination of his employment is a nullity must plead and prove the following material facts. 1, the nature of the employment. 2, the condition of service. 3, the circumstance under which the appointment can be terminated. I intend to analyze the pleadings and evidence in this case in the light of the material facts 1 to 3 above, and will only refer to the arguments of the parties where necessary. The nature of employment in the instant case is undoubtedly one without statutory flavor, and it goes without saying that all the incidents thereof are to be available and cognizance depending on proof. In any event, whether an employment with statutory flavor or not, or under the common law, principles of master and servant, the fact of the employment and the terms and conditions of same must not only be pleaded, but must be proved by evidence before a determination of the validity or otherwise of determination by the court. This is the case of Aji and Chad Basin Authority. Next is the circumstance under which the appointment can be terminated. Generally, the onus is on the claimant to prove that the termination of his employment is unlawful, null, and void. The foundation of the claimant case, as can be gleaned from the pleading, is that his employment was terminated by a letter dated 15th May 2019 without any reason stated by the defendant and without any wrongdoing by him. It is still incumbent on the claimant to prove that the termination of his employment is wrongful. In his bid to prove his claim, the claimant tendered 15 exhibits, that is exhibit CW1 to exhibit CW15, and out of which only 3 exhibits are of any moment. These are offer of appointment, that is consultant VLR exhibit CW1, termination letter exhibit CW113, and human resources policies and procedures December 2016 exhibit CW115. Apart from the aborted or failed attempt by the claimant to show that the termination was done in disregard of defendant exit procedure provided for in exhibit CW15 at the point of final address, there was no attempt to marry this exhibit with validity or otherwise of the claimant termination in this case. At best, The only advantage of Exhibit CW11 is to show that the claimant was a staff of the defendant who can be terminated by 1 month's salary or salary in lieu of notice. The letter of termination is only a confirmation that the defendant did not give any reason for termination without any pleadings or evidence to breathe life into Human Resources Policies and Procedures 2016. The exhibit remained dormant and of no evidential value. With this miserable state of pleadings and evidence by the claimant, I have no hesitation in finding and holding that the claimant has failed to prove that the termination of his employment was wrongful, unlawful, null and void. But can this therefore be the end of the matter? I think not. Although with this finding, the evidential burden did not shift to the claimant, to the defendant, as court of first instance, I am enjoined to consider the evidence of the defendant anyway. To start with, the defendant contended that it does not require the claimant to do something wrong or to give any reason before terminating the employment, the claimant appointment. To prove this, the defendant had recourse to CW11, Letter of Employment, and CW115, Human Resources Policies and Procedures 2016, which made provisions for termination of the contract without reason or infraction by the claimant. In paragraph 4 of Exhibit CW1 and Article 11.2.4 sub B of Exhibit CW15. It was also the contention of the defendant that the only time the defendant can be obliged to give reason for termination under international best practice is when it is pleaded and proved as a question of fact, as in the case of Emana, Edet, and Fidelity Bank, delivered by Kanyip J, as he then was on the 17th December 2019. The defendant also called in support the recent case of Uba and Idigbe, which reiterated the powers of the defendant to hire and fire without reason or explanation, thereby putting the controversy to rest. It should be noted, however, that the case of UBA and Idigbe cited by the defendant cannot be assessed by the citation given by the defendant. Since the issue of international best practice is not a live issue, in this case, it is needless to belabor the issue. It goes without saying, therefore, that since the claimant has failed to discharge the burden of proof that the determination of his employment was unlawful or wrongful, the issue whether the defendant has debunked the evidence or stand of the claimant in this regard is rendered academic. What is then the fate of the other reliefs in this case? I start with relief B, which is for the payment of claimant salaries and entitlements from 5th May 2019, when the appointments were purportedly terminated till the determination of this suit until judgment in this suit is fully satisfied. It should be noted that the claimant is entitled to all his salaries and emoluments, as if he is still a staff, is not tenable. The law is that while there is a purported termination or dismissal as this one, a declaration that such contract exists is rarely made. This is because a court will not grant specific performance of a contract of service. See the case of Carbon Metal Nigeria Limited and Active, Osheore, and NEPA, Ifeta, and Shell Petroleum. Next is Relief C for the payment of the shortfall of 2.6 million being part of the surveillance pay. The law is that in labor case, it is the claimant who has the burden of proving his entitlement to the claim and the quantum of his claim in terms of how he came by the said claim. To prove an entitlement, the claimant must refer the court to the exact provision of the law, instrument, or document that conferred entitlement. See Oyo State and Alaji Apapa, Mohammed Dungus, and ENL Consortium. In other words, it is the duty of the claimant to plead only such facts and materials as are necessary to sustain the relief sought and adduce evidence to prove same. See Gabriel Active and Cabrometa. From the pleadings and evidence in this case, nothing of this sort happened. And I think the claimant has not satisfied the twin condition of entitlement and quantum initiated in the case of Mohammed Dungus and ENL Consortium, and is therefore not entitled to the relief. Similarly, the relief is a monetary claim in the nature of special damages, which must be claimed specially and proved strictly. The claimant did not plead or adduce evidence of such facts and materials that are necessary to sustain this relief. Similarly, the relief for cause of action in the sum of 1 million cannot be granted. The claim is monetary in the nature of special damages, which must be specially and proved strictly. The claimant did not plead or adduce evidence of such facts and materials as are necessary to sustain this relief. The same is also true of relief F for the cause of this action, which is for all intents and purposes is also a monetary claim. Relief D for the payment of general damages for wrongful termination. This head of claim cannot be granted. This is because damages of whatever kind are a function of liability, and that where the claimant failed to establish liability of the defendant, as in this case, the claimant will not be entitled to award of damages. This is Union Bank, Nigeria PLC, and SORES. Relief E for interest of 20% interest per annum on the judgment until same is fully liquidated. In the first place, the judgment in this case is not in favor of the claimant, and therefore the relief is dead on arrival. In any case, such interest can only be claimed where it is contemplated by an agreement between the parties or under a mercantile custom or under equity. See the cases of Reynolds and Rognock, JK Investment versus Nigeria, Diamond Bank and Partnership, Sani Abacha Foundation and UBA, Nora and Ofama Puda, Elicon Nigeria Limited and UBA, to mention but a few. The case of the claimant is therefore hereby dismissed for lacking in merit and proof. I make no order as to cause. Judgment entered accordingly. Can you hear me?
My Lord.
Good. In the absence of any other business, the court will read. Thank you.
Thank you, my Lord.
Thank you.
All right.